all the VA medical centers throughout the country and the ones overseas and pull up every veteran's records. And then they can download them and upload them into the claims file. So you don't really technically have to get them, just list them on the application.
When I got off active duty years ago, 1970, they pre-qualified based on my injuries when I was in service. Do they still do that? They sent me a letter saying you're eligible and this is your percentage.
I mean, they are supposed to.
Oh,
I would say for situations like that, and I'm going to move on to service-connected disabilities now because I'm going to, before I get on my soapbox, because it's related to this. When it's that clear, people that are injured in combat, people that have Purple Hearts, the system works. It is the people that don't have paperwork that follow them up where we get into service-connected disability issues. So think about anything else is perfectly clear. When it happens on duty and there is copious amounts of records of it and medical treatment of it, the VA will generally not mess it up right away. Where the veteran feels they will mess it up is in the quality of treatment they get or the amount of compensation they get. But the responsibility of it, that part, they will generally get right. Where the issues come up with the VA not taking responsibility for things is where the injury or the record weren't clear or weren't apparent at the time. Or where the amount is, again, the amount of compensation they receive is what's in dispute. Where the VA says, well, sorry, this thing happened to you, we messed that up. Here's a check for $273 a month. And the veteran says, well, I want a lot more than that. And that's where most of the practice, where lawyers get involved, where litigation happens, occurs. And this is just the truth of handling these kind of cases. We're not seeing people come through that were blown up in IEDs and are missing 3 limbs, and the VA is saying, well, that's not our responsibility. That's just not what comes across the desk. It is almost always issues and injuries that are just not that apparent and clear, or are lacking records, or lack documentation at the time, or lack treatment by the VA or professional medical professionals that kept records that the VA had access to. So let's say what I'm talking about when we talk about service-connected disability. What that means is that the veteran's current disability was caused by something that occurred in service or was aggravated by service. So they're looking specifically at that period of service, whether it's 6 months, whether it's 4 years, whether it's 20 years, the injury or the aggravation of the injury occurred during that time period. And that injury is ongoing, that right now you still have issues related to that incident. It's not, it's not like a tort practice. It's not I was hurt and here's my compensation for being hurt. If you were hurt then and you're fine now, according to the VA, you're not entitled to any compensation. It has to have an ongoing component. When the veteran applies for disability, they have to show them 3 things: that they have, that their character of service makes them eligible, that they have, by medical records, a current disability, and that there's a connection between their current disability and something that occurred while they were in service. One of these 3 things is always going to be missing when the veteran gets denied, and what you're doing as an advocate for that veteran is figuring out which one of those 3 or all 3 went wrong. So when we talk about ratings, we're talking about is a scale that goes from 0 to 100%. So you'll hear terms like 100% disabled veteran. What does that mean? Well, the VA rates every disability at a percentage. 0%, 10%, 20%, it's always by tens. Each disability has a rating like that. So you may have a leg issue that is 20% and an arm issue that is 10%. Those ratings combined add up to a maximum of 100%. So even if you have multiple injuries that would be considered 100%, 100% is the cap. What those percentages mean is how much the VA will compensate you on a month-to-month basis. So a 10% rating is about $173 a month. 50% is, I'm going to do the math wrong, so 50% is I think about $1,300 a month. 100% is about $3,000 a month. So it scales up. There's a big gap between 90 and 100%. I think 90% is about $1,700. So when a veteran talks about their rating, that's what they're talking about. The overall goal to maximize your situation is to get to that 100%. Once the 100% is reached, even if you have ratings will take you above that, you cannot get more than that $3,000 based on your service-connected disability. There's other things they can add on, special monthly compensation, spousal benefits, other stuff we don't have time to get into today that can bring above that level, but that's generally the cap that they're looking at. The VA does math that makes no sense. So somebody has a 50% service-connected arm injury and a 50% service-connected knee injury is not 100% disabled. They combine them and create this math that will get them at like 60 or 70%. So you can't just add the percentages together to figure out what their rating is. The VA has a complicated formula that produces that final rating. If you're only looking at compensation connected to one particular issue, it's pretty straightforward. You know, something minor that doesn't show up on a day-to-day basis can be considered disability, like tinnitus or hearing loss. So I think tinnitus and hearing loss are the most commonly compensated things, usually at 10 or 20% rate. And you would interact with a veteran on a day-to-day basis and have no idea that the VA considers them a disabled veteran. So the definition of disabled for the VA purposes is different than what you would think of in common usage and what Social Security would consider disabled. It does not mean unable to work. It does not mean visually or physically disabled. It means that according to the VA, you have a negative effect on your day-to-day life that occurred because of something in military service. Service-connected disability, again, does not prevent you from working. So you can be 100% disabled according to the VA and have a full-time gainful employment. That does not affect your ability to collect that benefit, and if it does not, again, interfere with your work, then you're free to do that. So the burden becomes on the veteran to show how they and something became service-connected. For the most part, the military does not keep good records of minor incidents. Major incidents or people where people get in trouble, they usually do a lot of paperwork for that. But kind of the minor day-to-day injuries of people falling off things or things falling on people or people falling on people is generally not going to create a paper trail or create a lot of medical records. A lot of this stuff is treated at the troop level by medics who aren't, licensed medical professionals. And again, they don't necessarily create a paper trail for that. There's no paperwork you get for Motrin and water. So a lot of this stuff isn't documented when it occurs in service. Veterans are given their records when they leave the service, and they generally lose them within 6 to 8 months. And it can be difficult to establish these based on the military's records, but there's a lot of stuff you can do to substitute that. We'll talk about that stuff a little later. So almost all of the litigation has to do with what happened in service. It is a matter of something happened, it wasn't properly documented at the time, and now the burden is on the veteran and the advocate to recreate that documentation, either by locating it or by convincing them through other evidence that the incident occurred the way the veteran describes it. I think I mentioned these before. A service-connected disability doesn't mean that you can't work. It's totally different than the definition that Social Security uses, so those will rarely overlap and mean the same thing. The VA can rate someone at 0%. That means they don't give them any compensation on a month-to-month basis, but if the condition becomes worse over time, they've already taken responsibility for it. That's a matter of the issue at this moment not being disabling. The compensation is for the way the disability affects your day-to-day life after treatment. So keep that in mind in case you have non-compliant patients, that the VA won't treat you if you're not. The VA will not compensate you based on how bad your disability is if you're not following what the doctor is telling you to do in order to mitigate that damage. So if you say, for example, you have total hearing loss and the VA wants to fit you with hearing aids and you say no or you don't wear them, your compensation is at the level that you would get if you wore the hearing aids and not as it is. Mainly the non-compliant patient portion is going to be an issue related to mental health treatment and the VA's strong desire to medicate as heavily as possible people that have mental health problems, and people sometimes don't want to take the medication. And the VA can reduce or remove that compensation based on the non-compliance. To get service-connected disability, typically a veteran must apply, contrary to some person's experience in this room. Usually the VA is not catching the stuff on the way out the door, and you have to apply for compensation after leaving service. we mentioned a fee can't be charged for that. The date of the application or the compensation begins from the date that they receive an application that is eventually approved. I'm going to talk about this a lot more because it causes a lot of confusion amongst veterans. The VA is not going to compensate the veteran back to when the injury occurred. They're not going to compensate them back to when they were in service. They're going to compensate them back to the first time the veteran told the VA, I am injured because of service, and the VA agreed. If they applied for VA disability benefits and the VA said no, and they did not challenge that denial for more than a year, and they come back 5 years, 10 years later and apply again, the date that they'll go back to is the date of the new application, not the date of the old application. There is a big exception to this, and I'm not going to talk about it because we only have an hour and I don't want to confuse you. But generally, if they don't apply for the benefit after leaving the service until a long amount of time happens, they cannot be compensated until the date of that application that's eventually approved. I say eventually approved because some of these can take 10 years, 15 years, and that's fine. Their back pay will go back 10 years, 15 years, but it won't go back further than that. It has to be from that date of application. Okay, use an example here. Okay. So this is something that a lot of veterans are confused about or have questions about, and they say, well, I have proof of these injuries going back further. Under a tort system, you could get compensated for that. Under the VA system, you can't. That is a bright letter law that Congress has written. The VA has the power to authorize otherwise. So it's beyond the power of somebody in the VA to authorize payments going back to the injury, no matter how clear the evidence is, no matter how good the evidence is, until an application is given. We're going to talk a little more about practicing in front of the VA. Generally, the VA reviews the application and either approves it or denies it. If they approve it at a rating. So we assume that there's many people that get their initial application approved. We assume that because we never hear from them because it was approved, so they don't have any need for lawyers. So in general, we only see the ones that get rejected at least once before they come across the lawyer's desk or they start seeking legal representation. Most veterans initially apply on their own or with the help of a VSO, and if they are approved, it's not something that we deal with. Frequently, the VA will order them to go to an outside physician compensation and pension exam. They're called CNPs for short. That's compensation and pension, not compensation and pension. The purpose of the compensation pension exam is to send them to someone that doesn't work at the VA that can give the VA reasons to deny their claim. So it's important that veterans understand that that person exists primarily because the VA wants some medical evidence to minimize or deny the evidence their doctor gave them. Those are not treated as adversarial, the opposing counsel's doctor kind of visits. So veterans often come in with kind of a blissful ignorance as what the purpose is. But those are frequently ordered. Usually they use the CNP examiner's recommendation to decide what that rating is between 0 and 100. And if the VA denies the application or the veteran is unhappy with the amount of rating they get, then they do the appeal and then the actual practice and litigation begins. Are there any questions about service-connected disability up until this part? If you are confused at this part, you are a normal person. None of this stuff makes sense. Yes, ma'am.
Do you have to apply as an advocate with the veteran every year if there's a reduction, or is it once we get 100%, like that's the goal, we're good, or can they? You mentioned something of a reduction possible. Is that, I guess, every year they look at that?
No. They are supposed to periodically review claims. Typically, that will be with the type of claim it is and the age of the applicant. They will decide how frequently they review it. It is very inconsistent. Some people seem to get a lot of reviews and some people don't. They have to then provide continued evidence that their disability is where it was or is worse. Those reviews, they can go up or down. It doesn't necessarily mean they're going to reduce it. What that means is something across the VA's desk where they put an alert in to say, check in with this person after this many months to see if their doctor still thinks they are entitled to it and then decide. There is a designation you can receive, permanent total. So their permanent total disability cannot be reviewed. But that's something you specifically have to ask for, and they have a kind of complicated criteria to get there. But there is a circumstance under which you cannot get your case reviewed anymore for reductions. But for most veterans, it is something you're supposed to do. They usually look at the type of disability and the age when determining the frequency of they do it.
And the permanent and total disability then is something that they get for life, and at that point, can they still work, or no?
Well, the presumption with permanent and total disability is that they can't. This is something I'm kind of breezing over because it just gets kind of in the weeds on it, but there's